For admission, item number 1.
Your Lordship, in this matter, Your Lordship, Mr. S. Datta, senior advocate, requested me to make a mention on his behalf. He is going to represent respondent number 8, and I'm going to assist him, my lord.
Mr.
Mr. Surajit Datta.
Is that okay.
Yes. So, Your Lordship, if it could be kindly be taken up on the day after tomorrow, my lord. That is Wednesday, because yesterday he missed the flight. He's supposed to come, my lord. And this morning
I'm
also.
appealing for the.
This morning also.
I'm appealing for the petitioner.
Just a minute. We cannot see anything. Who is this?
Am I not this?
Just a minute. Oh, yes.
I'm sorry, I could not go. I'm appearing before Lordship from Guwahati.
Yes.
I'm appealing for the petitioner.
So?
On the last occasion, the notice was issued.
Yes.
And today it was fixed for consideration of the interim prayer. My lord, it's a very simple case where I have highlighted, the petitioner has highlighted that the private respondents number 8 to 11 who were awarded the work of selling state lotteries through paper only, and what they are doing is now they have taken some sort of a permission from the state and they are conducting the lottery business through paper but online, which is prohibited under the law, not only by the the state government but also by a central government specific notification that you cannot sell in a hybrid manner. Absolutely clear. Now this is resulting in serious loss to the state exchequer and as well as public interest, in the sense that there has been clearly a violation of law. And your lordships are aware. In the case of S.P. Gupta, that famous case of independence of judiciary, there I'll read one paragraph which says if there is any violation of law or the constitution, my lord, if this itself is a public injury and any person from the society can come before lordship and complain. And the prayer I have made is very, very innocuous, my lord. Since the work order itself says that they have been given the work of selling paper lottery, online they cannot do. This is what I have prayed. If they are objecting, that itself shows that they are conducting business through online, which is not permissible under the law.
Okay, only problem, Mr. Mazumdar, is that
My lord.
notice was issued only on 28th of August.
My lord.
And now it's just 10 days have gone by. So I think we have got to give some more time to the respondents. We cannot say deemed service.
Respondent has already entered appearance. The main respondent has already entered appearance.
But then what about so some are main, some are what?
Others I have imputed, but I have not claimed any relief against them directly, my lord. Today's interim prayer is directed only against respondent number 8, who has already entered appearance.
No, that may be true, but then he needs time because the senior counsel is asking for, I think,
accommodation.
11th date, 11th September.
My lord, may I then suggest, I am told, I have not got a copy, that the private respondent has also filed an application assailing or challenging the maintainability of the PIL itself. I am yet to get a copy, but I have been told that they have filed an application. I would like to respond to that also. If your lordships are thinking in terms of granting them some time.
The problem is that you all know more than us what is going on. We have not even seen that application. So, unless those applications are before us, we cannot make any comments on how to go about it.
My prayer is in consonance with what your lordships are thinking aloud. What I am suggesting before your lordship, subject to your lordship consideration, since they have filed an application challenging maintainability, I would like to respond to that. And if your lordships are thinking of granting them some time because they could not appear, then I'll pray that let the matter be fixed on 30th so that I can also physically appear before lordship.
No, so what we are going to do is, since they want 11th as the date, we will fix that date, the next date. Let that application, if it is filed, has it been filed?
Yes, this morning only.
Okay, so let that application be filed on, be listed on 11th also, and then we'll give you time then on 11th. Okay, because it's not before us. That's the problem.
I see, my nice.
Right. Okay, right. Mr. D. Mazumdar, senior counsel appears virtually. So, sir, Mr. B. Lalrang Enga, appearing for the respondent number 8, submits that the senior counsel, Mr. F. Datta, will be appearing on behalf of the respondent number 8 and prays for time and prays that the matter may be listed on 11th of September. He also submits that an application has been submitted by the respondent number 8, which however has not been listed today. Ms. Lal Nundui appears for 1 to 6, while Ms. Sairam Sangpi CG appears for respondent number 7. Any comments to make? Not yet.
Please, Your Lordship. My Lord, I'll be entering appearance on behalf of respondent number 9. I'll be filing my vakala during the course of the day.
Okay, Mr. Lal Fakoma will be appearing for respondent number 9 and submits that he will be filing a vakalat nama during the course of the day.
I would also like to place on record that we are yet to receive a copy of the petition.
Writ petition. He submits that a copy of the writ petition has not been served upon the respondent number 9. Next. How come when they issued notice it has to be
Notice
there?
was issued. We became aware of the filing of this case, but I don't think it has reached our office because it was sent registered post.
If it's necessary, we'll
Our
provide
office is
You
in
provide
Bombay.
another copy. Okay. Okay. Right.
It's Bombay office.
Next para, you write. Office note indicates that notice was issued to the respondents number 10 and 11 on 28/8/2024. However, there is no service report as on date. On the prayer made on behalf of the respondent number 8, lists the matter on 11.
Obliged.
Keep your blame.
principal seat matter for withdrawal, item number 1.
Just a minute, huh? Yes. Yes, who is appearing?
Lordship,
I can't hear you.
Lordship, I am appearing for the petitioner.
So what do you want?
Lordship, unfortunately, it was filed. We want to withdraw the same.
Okay, Mr. B. Sharma.
S. Sharma, Lordship.
Mr. S. Sharma appearing for the applicant. Prays that he may be allowed to withdraw the application. Mr. L. N. Dinginge appears for?
But caveat, my lord.
For?
Respondent number 1.
Respondent number 1. While Mr.
And annexing, Your Lordship, I am for respondent number 2 and 3.
N. Annexing appears for respondents number
2 and 3.
2 and 3. The prayer of the applicant's counsel is allowed. The application is dismissed as withdrawn. In all 1, 2, 3 matters, correct?
Yes, Lordship, on all the three.
Okay.
Respondent number 5, my lord. Respondent number 5.
L. N. Dinginge for respondent number
5, my lord.
5. Okay. And annexing for respondent number 2 and 3.
2 and 3, yes. Thank you.
Deeply opposed.
Isol bench matter.
Yes.
I seek your lordship's
Petition.
indulgence, your lordship. If I may be allowed to mention an item which I had filed on Friday.
Ah.
It has not been listed. It's regarding the transfer of the petitioner in violation of the statutory recruitment rules.
Violation in transfer.
Yes. The recruitment rule says the post should be filled up only by promotion.
Ah.
And the question of a transfer or deputation does not arise. So now they have transferred the petitioner out from the post and transferred another officer to the same post. But the question of transfer does not arise because the post as per the RR is to be filled up only by promotion. So it is in violation of the recruitment rules.
So when do you want? Tomorrow?
Today, Your Lordship. Yeah, because as per the office memorandum, the officer has to take charge within 5 days and 5 working days.
When was the transfer order issued?
3rd of September, Your Lordship.
Okay.
I'm alone.
My lord, part 2, item 11 may be taken up next week, my lord. This one
Part
criminal.
2, item 11.
Yes, my lord.
On the prayer of Mr. B. Rala Menga, learned counsel for the appellant, this is the matter in the next week.
Much obliged.
Your Lordship, item 4, part 2.
Yes.
This may come up tomorrow.
Yes.
I'm alone.
Seek Lordship's indulgence in mentioning item 8 of part 2. My lord.
Yes.
My lord, this matter may come up on Thursday.
Are you sure?
Yes, my lord.
Okay.
I am for the respondent.
It will remain in the list.
My lord.
My lord, I seek for your indulgence in regards to part 2, item number 2.
Yes.
I'm appearing on behalf of my senior. He's out of station. If this matter may be taken after a week.
Okay, right. On the prayer made on behalf of the appellant's counsel, this is the matter after 2 weeks.
Oblige.
Item number 10, part 2, my lord.
Yes.
If it may be listed after 2 weeks, my lord. I'm appearing on behalf of petitioner for
Okay,
my...
right. No.
Item
This is
number
the one
10.
we said that it should be listed this week.
My lord, my senior is out
Your
of
senior is
station.
not there, we'll dispose it of in the absence of a senior. Give me item 10. Specifically, we passed an order last week. You cannot do bench hunting.
My lord, I'll just contact with my senior and...
If he comes, let him come. If he doesn't come, he'll have to go to Supreme Court.
Yes, my lord.
Tell him that.
I'll take instruction for my senior, my lord.
Oh, no. Okay. This is different. I think this is different, right? On the prayer for adjournment made on behalf of the petitioner's counsel, this is the matter after?
After 2 weeks, my
After
lord.
2 weeks.
Yes, my lord.
Okay.
Thank you.
May I please, Your Lordship, if I may seek your indulgence in making mention of part 2, item number 6.
Part 2, item 6. Yes.
Lordship, if this matter may be taken up after 2 weeks, Lordship.
On the prayer made on behalf of the petitioner.
Respondent, Lordship. All of them.
Respondent's counsel is the matter after 2 weeks.
Daily list, item number 1 and 2.
My lord, I seek your indulgence in making a mention. May this matter may kindly be listed after 4 weeks.
Why?
Because, my lord, my senior counsel, Mr. Lalsoy Rema, had a knee injury.
Knee injury.
Yes.
So there's a thing called virtual appearance.
My lord, and also he is in out of station.
That is why there's something called virtual appearance.
Yes.
Okay, this item 1 and 2, what has happened to the writ appeal?
Yes, my lord. On Friday, my lord, according to it was stated, my lord, readable 8, my lord.
Huh?
On last Friday, my lord, which is just this court, my lord, state the readable 8 up to.
Oh, okay.
Yes, it was my order is with me, my lord. This.
Okay, we state that thing.
Yes, my lord.
So if it is stayed, then, so this has,
No, my lord, that's a different matter. It's a different award. This is regarding Kontui. That item, WA 8 of 2024, it's regarding Hortoki.
so this is WA 8 of 2024.
My lord.
What has happened to it? It's still pending.
State, my lord,
No, this was issued in the matter.
my lord, this is the order, my lord.
The
My lord,
single,
in the meantime, the effect of operation of order to so and so shall remain state.
single judge order was stayed and notice was issued. Your lordship. In that
Okay,
matter.
then what can be done here?
Yes, my lord.
My lord, this, in this matter, why it was clubbed together, one thing is that they are common petitioners.
No. So unless that writ appeal is decided, this case cannot be decided.
Yes, ma'am.
Because that single judge order which you have relied upon has been stayed.
Here, we,
Well, that is the thing. Because your case is similar to that case in the single bench judgment. And that has been stayed by the by the division bench.
Another case is pending also principal bench, my lord, to read appeal, my lord. These
Okay,
are the
right.
statement.
So we'll list it after the vacation. Right. Counsels for the parties submit that writ appeal 8 of 2024 is still pending before the division bench in the principal seat. Accordingly, release this matter after the vacation.
My lord, date may fix, my lord.
When?
My lord, the principal bench 24 October fixed, my lord. So after that, my lord, 30 of October, my lord. 30.
Okay, 30th of October. List the matter on 30th October.
Item number 3.
Yes.
Lordship, there has not been any progress in this.
Tell me one thing, Mr. Counsel, is there any arbitration clause?
Page 73, my lord.
There
Special
is.
conditions of contract.
Then you avail of that. Why should we go into those questions?
Lordship, let them file the affidavit.
No, Mr. Counsel, this is the law. When there is an arbitration clause, as per various judgments of the Supreme Court, you see, when there is an arbitration clause, then you have to go by that.
Yes,
can
that's true, but we may not be able to avoid that. But the thing is, if the dispute can be settled by direction of this honorable court, I think that will be easier.
No. How can?
Arbitration, Lordship, it is there, but let them file their affidavit and let them raise the issue
No.
as to whether there is any dispute or not.
Please look at the judgments of the Supreme Court. The only thing the High Court is supposed to do is see if there is an arbitration clause and whether the matter has to be decided by arbitration. That's all we have got to look. We are not supposed to go beyond it.
That's true.
Various Doyle's cases there. There's so many judgments.
From whatever dispute that may be raised in the affidavit, we'll see whether there's anything to be decided.
It is not disputed by you that there's an arbitration clause which can decide the dispute. It's only when you say that this matter cannot be decided by an arbitration, through arbitration, that we should go into it. When it's not disputed by you, that it is a matter which
the
can
provision
be
is there. The provision is there. But Lordship, it may be something which may not be within the scope of this arbitration clause.
No. It is here, very much here. Very much here. Look.
It provides.
Section 8. You apply Section 8. In case of dispute arising between the employer and the domestic contractor relating to any matter arising out of or connected with this agreement, such a difference shall be settled in accordance with so and so. So you have got to agree to, that is the only way out.
So in that case, whether the matter has to be referred to the Indian Council of Arbitration?
No. Out here, the condition is that either you agree to an arbitrator, both of you. If you do not agree to an arbitrator, then there is one where you will choose one arbitrator and they will choose an arbitrator and a third arbitrator will be appointed by the two arbitrators. If that is not possible, then you will come under Section 8(1). All this has to be done within 30 days and that's the only way out.
Will the court appoint an arbitrator for us?
That happens only when either you don't agree, because what the clause says that the parties shall make efforts to agree on a sole arbitrator.
Yes.
And only if such an attempt does not succeed and the arbitral tribunal consisting of 3 arbitrators, each to be appointed by the employer and the contractor, and the third arbitrator to be chosen by the 2 arbitrators so appointed by the parties to act as presiding arbitrator shall be considered. In case of failure of the 2 arbitrators appointed by the parties to reach a consensus within a period of 30 days from the appointment of the arbitrator appointed subsequently, the presiding arbitrator shall be appointed by the Council Indian Roads Congress. So there is one thing. Now, I can give you a time limit within a certain period of time, within say a week or within 2 weeks. You agree upon a arbitrator. If that is not possible, then you appoint one arbitrator and you write a letter to them under Section 18, give me the Arbitration Constitution Act, 1996. You write a letter to them saying that this is my arbitrator, now please choose your arbitrator. and you will give them 30 days time. If within 30 days, if they appoint an arbitrator, then these two arbitrators will choose a third arbitrator. And then now what will happen sometimes is they might not choose their arbitrator within 30 days, or these two arbitrators might not be able to choose the third arbitrator. In that case, you will come to this court under section 8.1 and you will ask, or section 11.8, I think. You will ask this court to appoint the arbitrator, in which case we will appoint. And even where there is a provision for appointment of 3 arbitrators, sometimes we appoint only 1. It depends. This is slightly fluid situation here because of various judgment. Because you see, at the end of the day, it's more financially wise to have 1 arbitrator than 3 arbitrators, because you will be paying a lot. So
Let me check the provisions, Lordship.
yes.
Let this matter come up in tomorrow.
Yes, section 11.8. Section 11.8. ठीक है, no, section 11, section 8. Okay. Right. Yes, anyway, why have you lessened the amount?
We are yet to receive any instructions, my lord, till date. Nothing has been communicated as of now, my lord. We are waiting for the same.
Is
It
it
has
this
been
writ-
more than 5 months.
This writ petition has been filed on 23 April.
Yes, my lord. It was listed on the 25th. Motion
Correct.
stage. Yes.
Now, by the time you file your affidavit, the entire contract could have completed. Has the contract been stayed? Acha, you're working.
Yes. It's not state.
You're working.
We have continued the work.
You're not answering, so this is the only way out. And most probably, you just think about it, because they are going to adjourn the matter time and again.
That's true.
And and it'll be a tough call.
And they're also promising that for whatever work that has been done, submit your bills and then we'll make payment and all that. That kind of understanding is there. But till date, what I have stated before the Honorable Court, have not been able to make any response.
Anyway, you look it up, because I do not know what is the reason for, why you not answering this?
My lord, I've even sent a reminder with regards to this matter. But till date, they have not given me any comments also, my lord. So I'll reach out to the department as well again, my lord.
You tell the engineer in chief to appear virtually.
I'll speak
No,
to the
no,
concerned
tell
department.
him to appear virtually. This is not the way. Otherwise, we'll give you till Wednesday, day after tomorrow.
Yes, my lord. I'll speak
Yeah,
to the
and
concerned.
otherwise, you tell him he'll have to appear personally before this court.
Yes, my lord. I'll speak to them, my lord. Today itself.
This is not the way to. You see, this is an issue where his contract has been halved, I think. Correct, halved.
Yes.
Right. Mrs. Sheila Ramzawa, learned counsel appearing for the petitioner, submits that despite more than 4 months having passed, the respondents have not filed any affidavit, giving reasons as to why the contract of the petitioner has been halved. HALVED, account. Mr. Samuel Warren has accounted. Additionally, submits that he will instructions positively by the next date. List the matter day after tomorrow. Failure of the additional AG to obtain instructions may invite consequences.
5 and 6 also.
5 and 6 also. 4, 5 and 6.
Hello.
Orders, item number 7.
In this case, my lord, lower court record received, my lord.
Huh?
Lower court LCR received, my lord. This,
So,
my lord, so paper book is required.
huh?
Paper book, my lord.
Why? RFA?
RFA, my lord. And my lord, the evidence
What is
of
this compensation is for damages or for acquisition?
damages, my lord.
For damages?
Damages, my lord. My lord, here there is a court witness, my lord. It is in particular, my lord. So not able to read, my lord.
So this compensation is not for acquisition of land?
Not
It's
acquisition,
for
my lord.
damages?
Yes, my lord.
So what did the lower court say?
Lower court says, my lord, they are entitled as their direction for spot verification, my lord. They, according to them, they came to know in 2019, my lord. And 2022, my lord, direction for joint spot verification. And there's the surveyor, my lord, verified, my lord, according to him, my lord. But I don't understand this language, my lord. Court says, my lord, there is damage, my lord. There was damage into 2019.
Where is that? Where is that? Surveyor report is there.
Surveyor report, my lord, it is not there. The record is there.
Huh?
LCR record is there.
Give me the LCR report. This is damages pertaining to which area? Which year?
My lord, this day came to know 2019, my lord. And
But
my
when-
lord, this
when-
land, some of the land of the defendant, my lord, the respondent, my lord, this is acquired 2011, my lord. And from the adjacent land, it was damaged, my lord. Their claim, my lord. So this is the claim. And my lord, this it was the contractor work was done by contractor, my lord. And so far, my lord,
Where is it? I've got where is the survey's report or evidence?
it was discussed, my lord.
Your Lordship, it's in the LCR.
Correct. Where in the LCR?
I didn't receive the LCR, my Lord.
Mr. Counsel, you're supposed to have a copy of the evidence with you.
Well, judgment is from 23, page 23, 11, my lord. This judgment, my lord. And so far, page 34, my lord.
Huh?
Page 35, my lord.
35 of what?
This my appeal, my lord. Exhibit 3 is the report. Actually, it is VC pass, my lord. This land was VC pass, my lord. Now, so there is damage of crops, my lord. The VC pass, my lord. And my lord, in the report, surveyor reported the land of plaintiff now one is within this Kamrang PC area and located between the railways and tunnels and so and so constructed, which was carried out by NC Das company, my lord. But this company was not made party. This is the non-general necessary party, my lord. This was our plea in a written statement, my lord. So far, our ground also, my lord, whatever this contract, my lord, it was the contractor only what he needs, my lord, he will arrange, my lord, not by the railway, my lord.
Anyway, what to do now?
My lord, this I have seen the law court report, my lord. Some witness of the court witness, my lord, this is in vernacular, my lord. I could not understand, my lord. So it required to translate, my lord. And this other, my lord, paper required and may direct.
At your cost. At your cost.
Yes, my lord.
Okay, right. Mr. S.K. Medi appeals for the CGC appeals for the appellant. While Mr.
RK Mustankima.
corresponding number 1 to 3.
Appears for respondent number 1 to 3. Miss Caroline K. Lung appears for respondent number 4. The appellant's counsel submits that some of the evidences are in the Mizo vernacular and the same needs to be translated. He further prays that a paper book be prepared at the cost of the appellant. The prayer of the appellant's counsel is allowed. Registry to prepare the paper book by translate and also translate the evidence which are in the Mizo vernacular.
My lord, translation by the registry, my lord, this is because
Huh?
translate will be by the registry, my lord.
Naturally,
because-
they are going to make
Yes,
everything. This is the matter after preparation of the paper book.
my lord, there is an interim order, my lord, let me.
Interim order to continue till the next.
May I pray the on 30th of October, matter will be listed again, my lord, because
Give them some time.
if fixed now, then sometime miss, my lord, that is
Okay, list the matter on 30.
30.
30-10.
Highly appreciated.
Item number 8.
Item number 8, my lord, now today I'm going to file, my lord, an additional affidavit, my lord. As the last time court allowed to file an additional affidavit. Now, I've already started with copy, my lord. So may I pray this matter will come on 23rd of this month, my lord. September, my lord. Next.
You are going to file additional affidavit?
Yes, my lord.
Mr. S.K. Medi, CGC submits that. He needs how much time?
My lord, today I'm going to file, my
He
lord.
submits that he will be filing an additional affidavit
The
within the course of the day. He accordingly prays that the matter may be listed on
23rd of September, my lord.
23 September. This is the matter on 23 September. In the meantime, Mr. F. Lalengena, counsel for the respondent numbers 1 and 2, may file additional written objection to the additional affidavit.
Highly.
Item number 9.
My lord, this is a criminal petition filed by the state. This is an application under section 442 of the BNS Act along with Red 397 of the CRPC.
So we have to issue notice.
Yes, my lord, there's a delay application also.
I heard Ms. Linda L. Fumble, PP, who submits that there is a delay of
56 days.
56 days in filing the appeal against the impugned order dated 10/4/2024 passed by the Learned Special Court NDPS Act ISOL in sessions registration number 67 of 2024 under section 22C NDPS Act. Issue notice returnable in 4 weeks.
Okay.
Applicant to take steps for service of notice upon the respondents for a registered post with AD within 3 days. Leave the matter after 4 weeks.
Okay.
No. Hearing item.
Hearing list, item number 1.
Lordship, every 50 years, there was a flowering of bamboo in Mizoram, which is followed by famine.
Has that got anything to do with this case?
Yes, my lord. So,
I doubt. Who's for the other side? Where is she? Okay, tell me your case.
so my lord, first of all, may I take you to my rejoinder affidavit?
No. You don't read a novel from the last page to the front. You have to go in the clockwise direction, not anti-clockwise.
Okay, my lord.
You start from the beginning. What is your case?
I was sanctioned a loan.
You have sanctioned the loan.
Yes, my lord.
Okay, remember the words that you are using. You were sanctioned the loan.
loan was sanctioned to me.
Okay, no. So loan was sanctioned to the, so there's a loan.
Yes.
Now what about the loan? What happened?
They are in three phases. First phase, second phase, and third phase. They released first and second phase.
Correct.
And the third phase was not released to me. So I started my business, and before I flew off, then the third phase could not be sanctioned to me. And I had mortgaged my land for that loan. And at page 14, my lord.
14.
Yes, my lord.
Yes.
That was a sanctioning of term loan amounting to rupees 74 lakh.
Yes. So it's, remember the words used, it's a loan.
Yes, my lord. It's a loan.
Okay.
And first phase and second stage was released to me. That is 24 lakh 50,000 and 20 lakhs. So altogether it is 44 lakhs 50,000.
Correct.
And at serial number 6, my lord, mortgage of land building under LSC so and so. So I had mortgaged my land.
Right.
Then we had signed an agreement at page 16.
Yes.
Whereas at the second paragraph, my lord, whereas the borrower has granted industrial loan amounting to rupees 74 lakhs.
And you have signed this agreement with open eyes?
Yes, my lord.
No force?
No.
Okay.
Then I had repaid my interest from page 19.
You have to pay 19, huh?
From 19, that was from 31st 2007.
You pay you repayment of interest. Okay.
Yes.
So you have been repaying the interest only, not repaying the loan.
No, interest.
Where?
Loan interest. So totally it's amounting to rupees 11 lakhs. 11 lakhs 10,000. Then similarly situated person like me, those who got the loan from the BDA. My lord, the sanction amount was from the Industries Department.
You see, your loan is not from the BDA, it's from the
ZITCO.
ZITCO.
Yes, my lord. So there was a general body meeting. May I take you to page 25, my lord?
Page 25, yes.
Serial number 1 is respondent number 1. Serial number 6 is respondent number 2. And may I read, my lord? The chairman welcome all the members present and Zemington Moya, director. That is the respondent number 3. Commerce and Industries and Executive Director, Board Bamboo Development Agency, presented and highlighted the agenda for discussion. He informed the meeting about the issue raised by the bamboo chipping units that the fund received from the Bafakos and ASIDE scheme under the Government of Mizoram and the Government of India as grant in aid was given to the entrepreneur 9 bamboo chipping units in terms of loan through Bamboo Development Agency, Mizoram. The same was also highlighted in the Chapter 4, Para 4.7 and Chapter 5, Para 4.7 in the 5th Report of Committee on Estimate 2014 to 2016 and also reflected in the Chapter 2, Para 4 of the 6th Report, March 2017. The Committee on Estimate opined that the method of giving out grant in aid as a loan was faulty. So, my lord, the committee estimate opined that the method of giving out grant in aid as loan was faulty. The committee, the entrepreneurs now requested the BDA to consider waiver of their loans in accordance with the report of committee on estimate, and they also requested for closing down of their respective unit. After detailed discussion, the meeting clarified that funds already given to this entrepreneur in the form of loan were not really so, and considering the source of funds, they were more in the nature of grants. And in this position, we reaffirm and consequently these bamboo chipping units which are already discontinued may be closed down unless the entrepreneur concerned are willing to revive them. So my lord, similarly situated person like me, those who are under the BDA, their loan has been waived off.
Who are they? Who are they? Who are these persons?
I don't know, my lord. It only said 9 of them.
Mr. Counsel, that cannot be, no. You have got to tell this court who are they? Who are those persons whose loans have been waived off?
My
You
lord,
have got to
at my additional
you see, the problem in your case is the agreement has been signed between you and ZITCO. Your agreement is not between you and BDA.
But respondent number 1, respondent number 2, respondent number 3 are there, my lord.
So what? Chief Secretary and all, everyone, they're in all the committees, there's so many committees. They're in so many committees. Now, this money, whether this was part of the BDA money, how do you connect that?
My lord, may I take you to page number 8 of my rejoinder affidavit?
Yes, page 8.
This is the detailed estimate devised for buffer costs under 12 Finance Commission of Industries Department for 2005-2006. Amount is, my lord, 630 lakhs. Page 8, my lord.
Yes, I've got it.
So at page 12, my lord,
Yes.
this is the sanctioning letter.
Okay, that's okay.
Yes.
So
my lord, then
how
we have,
do you see? Please, you see how do we know that the loan given to you is from the 630 lakhs?
it's from the, my lord, that's why, my lord, it's sanction of rupees 630 lakhs buffer cost scheme under 12 Finance Commission during 2005 to 2006.
So?
And it was sanctioned on 17 March 2006. So, my lord, the sanction amount at page 1 was after this.
Page 1?
Annex 1 of my read petition. Page 14.
No, it's not this, not that way, Mr. Counsel. I know what you're trying to get, but then you've got to connect the dots. It's your job to connect the dots. Now,
yes, my lord.
What you are saying is that the 74 lakhs was sanctioned from that 630 lakhs. But
yes, my lord.
Where is the connection? Show me some document. Yes, madam. He says, petitioner's counsel says that this loan amount that has been sanctioned to him
Yes.
is from that 630 lakhs. Is that correct?
Now, my lord, the respondent did not say that it is a loan.
I
They
know,
have
but
said that it is a share capital.
Huh?
They say that it is a share capital.
Whatever it is, Mr. Counsel, so what? So what do you understand? What do you understand by the word share capital?
Share capital, my lord, is the money which both parties are putting on to run the business. And I contribute some money, and they also contribute some money. For that, we have to sign joint venture. We did not sign any joint venture with the respondent. How can they say that it is a share capital?
I don't know.
Share capital, my lord, it's between the state government and ZIPCO.
Share capital between.
Yes, ma'am. And the ZIPCO has granted.
No,
this
no.
loan.
I want this. I want you to tell me. You have given some money to Zitco,
Yes, ma'am.
and Zitco has given some money to him,
As
loan
loan,
amount.
yes.
Now, is this money that has been given to him from this 630 crores, 630 lakhs under the buffer course scheme? From where did Zitco get the money? Or from where did government give the money to them? Was it from the 630 lakhs? You just answer this, that's all. What is your stand to that?
In that regard, my lord, I have inquired, but till today they have not given me the answer.
Yeah, that means they're hiding things. Then we'll call them. Who should we call? The secretary? Or with the consent file? He'll come tomorrow with the consent file.
Your Lordship, let the matter come up again. Let me inquire again.
You see, they've got to answer. Okay, I will direct. Right. Heard Mr. Edwin Longora, then counsel for the petitioner, as well as Mrs. Linda L. Famon, additional AG, Nizara. The petitioner's case is that the loan amount of rupees 74 lakhs, which had been granted to the petitioner by Zitco, wide letter number Zitco bracket L bracket close to /2005/995 dated 25/8/2006 was from the rupees 630 lakhs no, that was from the grant of 630 lakhs sanctioned for the buffer course scheme BAFFA-COS under the 12th Finance Commission during 2005-2006. Mrs. Linda L. Fumble, additional PP, shall obtain instructions as to whether the loan amount sanctioned to the petitioner is from the above sanctioned amount of rupees 630 lakhs. When can you get the information?
On Thursday.
This is the matter on Thursday. So that, I think that will clarify everything. That is what you wanted to, that is what you have got to connect. That is the main thing.
Oh, bless me.
And who are those persons who have been, whose loans have been waived?
My lord,
None of them, my lord. Under buffer course, none of them have.
name was not mentioned, but my lord, if I have in my additional rejoinder affidavit, my lord, I've stated all this.
Yeah, no, saying is different. It's like saying in America there's a lot of people who don't eat meat. So what? But then but we want to know who do not eat meat. So you have got to say whose loans were waived. You have got to prove it. You have got to prove. Just because you say something doesn't mean that it's the gospel truth.
My lord, we have applied to RTI also, but the RTI, they have not given me their names.
Then did you file an appeal?
No, my lord.
Then in the
have
RTI Act,
given me
there's a provision for filing appeal.
They have given me 2 reply, my lord, at my additional rejoinder affidavit. Then they have not mentioned their names. Only 9 bamboo chipping in industry.
But they have agreed.
Yes, my lord.
Oh, where?
At my additional rejoinder affidavit.
Additional rejoinder. Additional rejoinder. Rejoinder or
Yes.
additional rejoinder?
Yes.
There is an additional rejoinder.
Yes, my lord.
Additional rejoinder. Additional, okay.
Because I produced in a loose paper, my
Okay,
lord.
additional rejoinder.
At page 7, I am directed to convey government approval to the resolution taken by 21st General Body meeting of
Where are you reading, Mr. Counsel?
page 7, my lord.
I've got it. It says here in pursuant to. Correct. How does it start? The order?
In inviting a reference to the above.
No.
This was filed on 21/6.
21?
2024, 21 June.
I've got 27 June. Submission of by Lalura Pachau.
Submission of additional rejoinder affidavit
By whom?
in compliance of the Honorable Court Order dated 11/6
Correct. Now,
by Lalura.
correct. How? You're talking about that 4-line letter, 4-line letter.
Yes, yes,
That
my
is
lord.
page 8. That's not page 7. This pagination has been done by you, not by us.
Annexure 3, my lord.
Correct. That is page 8, not page 7. These are all civil court matters, basically.
And this is relating to Bamboo Development Agency again, ma'am. This annexure 3.
Correct. No, the only thing, you see, the issue is this. His basic case is that he has been given loan from that 630 lakhs, which was to be operated by the Bamboo Development Agency. Now, Bamboo Development Agency has given that money to Zitco, and Zitco has given to him by loan. Is that your case?
Yes.
That is his case. So that is why we have got to know whether the loan given to him was from the 630 lakhs. That is number one. Number two is with regard to okay, continue, huh? What have I said? Ah, 630 lakhs for the buffer cost scheme being run by the Bamboo Development Agency. Full stop.
Zitco, my lord.
$630 lakhs if it was Zitco, why should they have all these meetings? Huh? You were on the bus, now you have gotten off the bus, now you are running after the bus. Anyway, the additional lady shall also obtain instructions as to whether loans/grants given to bamboo processing units under the buffer scheme were waived. In respect of the, whether the grants, from the grant of rupees 630 lakhs were waived. No, grant given to 630 lakhs to various bamboo chipping units were waived. You see, Mr. Council, out here, only grants given to the chipping units were waived. Was yours a chipping
Yes,
unit?
chipping, bamboo chipping, yes.
Chipping units were waived. Full stop. This is the matter on Thursday. So this will clarify things, hopefully.
Promotion, supplementary list, item number 1.
May it please, Your Worship. The petitioner was working as the Chief Informatics Officer under the respondents. Initially, he was deputed, he was transferred on deputation to the state respondents on 19th of July.
What is the post he is holding right now?
Your Worship, if I may take Your Lordship to page 18, annexure 4.
Yes.
20th of November 2012, notification dated 20th of November 2012, on the recommendation of the Mizoram Public Service Commission, white letter number so-and-so dated 8th of November 2012. And in the interest of public service, the Governor of Mizoram is pleased to promote Pulaltha Mona, Principal Informatic Officer, to Chief Informatics Officer under Information and Communication Technology Department. So, Your Worship, he was earlier holding the post of Principal Informatics Officer, and by this notification, he has been promoted to the post of Chief Informatics Officer. And page 19 is the impugned transfer order.
Page 19.
Page 19, annexure 5. In the interest of public service, the Governor of Mizoram is pleased to order transfer of Dr. Laltha Mona, Chief Informatics Officer, ICT, to the post of Joint Secretary ICT with immediate effect and until further order. And page 20,
Yes.
annexure 6, serial number 2, selection grade MCS officer, Mr. James Lalnun Moya, Joint CEO, Mizoram, has been transferred to the post of Chief Informatics Officer, ICT, in place of the petitioner.
Yes.
So, the point I would like to raise, Your Lordship, is that if I may take Your Lordship to the recruitment rules, which is at page 15.
Yes.
This is the recruitment rules for recruitment to the post of Chief Informatics Officer.
Page 14.
Page 15.
15.
Page 15 relates to the recruitment for the post of Chief Informatics Officer.
Yes.
And page 17 and the table, which is
Yes.
at page 17,
Yes.
if Your Lordship will kindly see column number 11. Method of recruitment, whether by direct recruitment or by promotion or by deputation/transfer, and percentage of posts to be filled by various methods. 100% by promotion.
So,
Column number 12 says promotion from Principal Informatics Officer with 5 years regular service in the grade. So the only method of recruitment to the post of Chief Informatics Officer is by 100% promotion from...
No, that's all right, but
Yes.
that he cannot have any grievance.
So
You see, now what is wrong with the with his posting or with the transfer? What is wrong with the transfer?
The first point was that since the post can be only filled up by promotion,
That's a
it
different
cannot be
thing.
filled by transfer.
No, that's a different thing.
And
You see,
another-
the thing is that what is wrong with his transfer? That's all.
The wrong with his transfer is, Your Worship, there's no post of Joint Secretary ICT. It has not been created.
No post of
There's no post of... That is the second point raised by us.
No, the first point is no point. It's the first point. Whether you see he is a chief, it's not that he is not. If supposing someone had been appointed chief informatics officer by violating the rules while he was eligible to be appointed, then you have a case. But here he is already appointed as chief informatics officer, so that
Yes.
is not the issue. The issue is your transfer. You are aggrieved with your transfer, not with the somebody
Well,
else being appointed.
The next point, Your Worship, is that there's no post of Joint Secretary ICT which has been created by the state respondents. Para 10 of the writ petition, Your Worship.
Para 10 of the writ petition. Yes, madam.
My lord, we have not been served the copy, so I'm not
Oh,
aware of
oh, what is this?
Your Worship, we have already served. Your
No.
Worship. We have already served, Your Worship.
Served to whom?
it. But we're not aware that it will be taken up today, my lord. We're not informed that the case will be taken up today, so my lord, we have not gone through the copy.
Correct, correct. You should have given a copy. To
We
whom
gave
did
them
you
on
give?
Friday, Your Worship.
You gave it on Friday?
Yes, copy has already been served on Friday.
Served on Friday. Si Tlan Chiang Lima. That's you. Received copies of 1, 2, 3. H. Laldin Sangi. Who is Laldin Sangi?
That's one of our staff, madam. But we're not aware that the case.
It says
will be
government
listed
advocate. For government.
for-
That's your mistake. Your staff should have told you.
My lord, the keys may be there, but the thing is, we always give the files to some other government advocates or not. So we're not aware that the case will be listed today, so we have not gone through it.
Anyway,
Yeah, but it was our
you
duty
see,
to serve them.
this court is only interested in one point. Whether there is any post of joint secretary ICT. If there is a post, he has got no case. If there is no post, then whether you can transfer him to a non-existent post. That is the issue. Because the question of him being aggrieved by some other thing, that is a different issue altogether. Nothing to do with him. Some other persons who are eligible, Mr. Malhotra, some other persons who are eligible to be chief informatics officer, they can have a grievance. Not him. This is not a PIA. He doesn't want to leave his post, that much we understand. It's very clear from it. But the problem is whether there's a post of joint secretary ICT, I don't know. Can you obtain information whether there's a post of joint secretary ICT?
Yes, madam. Okay.
Because we can take it up at 2 also. We'll give you enough time. Find out whether there's a post of joint secretary ICT, then we can give stay order for the time being, and then for the next date, if you can come up with any notification, creation of a post, then his case goes. What do you want?
My lord, I have hearing matters in the other courtroom today. They are
Okay.
waiting for me, so I don't know whether I'll be able to get the information.
Okay, then we'll stay the matter for the till when?
Till next returnable date, my lord.
When do you want? It is a small issue. Only whether the post of Joint Secretary ICT has been created or not.
That is up to your
If
lordship.
if it is in existence or not. That's the only issue. Nothing else remains. Okay, right. Right, Mr. A.R. Malhotra, learned counsel for the petitioner, who submits that the petitioner has been illegally transferred to the post of Joint Secretary ICT from the post of Chief Informatics Officer, ICT, even though no post of Joint Secretary ICT has been created by the government of Mizoram. He further submits that in terms of the notification dated notification number A full stop 22012/33/2022 PNAR bracket CSW bracket close / loose 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 /11 page 20 dated 3/9/2024 issued by the Commissioner and Secretary to the Government of Mizoram DPNAR bracket CSW. The respondent number
Two.
two has been,
Serial number 2 in this order, yes.
no, he's not a party. The respondent number 4. The respondent number 4 has been posted as the Chief Informatics Officer, ICT. He submits that in terms of the Mizoram State Information and Commission Technology Department, bracket Group A post, bracket close recruitment rules, 2012, page 15. The post of Chief Informatics Officer is to be filled up by 100% promotion from Principal Informatics Officer with 5 years regular service in the trade, which qualification the respondent number 4 does not possess. Mrs. Linda L. Fumble, additional AG, is given time till next Monday. Is given time till next Monday to obtain instructions as to whether the post of Joint Secretary ICT has been created by the state of Mizoram. The stand taken by the petitioner's counsel with regard to the appointment of the respondent number, with regard to the posting of the respondent number 4 to the post of Chief Informatics Officer is cannot be said to be. No. The political. First of all, yeah, in the view of in the prima facie view of this court, may not have much bearing in this case, if the post of Joint Secretary ICT has been created by the government of India. Accordingly, leave this matter on next Monday, the 17th.
17.
Leave the matter on 17th. Good stuff. Till then, the notification dated 3/9/2024. That notification number and date issued by the Commissioner Secretary to the Government of Mizoram
Annexure 3 and 4 may kindly be stated.
shall be kept in abeyance insofar as where is that? And insofar as serial number 2 is concerned. That's all.
Nothing.
You see, the thing is that if there is a post, then nothing remains. If there is no post, then he's got a point. How can you post him to a non-existent post? That's all. But with regard to that other chief informatics officer, I don't think you've got a case. Unless there is someone who is eligible for that post.
PIO.
Yes.
PIO with 5 years
Yes.
regular service.
That's all.
Yes.
With respect to